District Judge Aileen Cannon, who was appointed to the bench by Trump, ruled that Special Counsel Jack Smith, who was leading the prosecution, was unlawfully appointed to his role and did not have the authority to bring the case. Here's how the federal government has used special counsels in high-profile investigations over the years, and how Cannon's ruling, which Smith said he is appealing, would affect ongoing and future cases. A brief history of independent counsels. Ensuring impartiality in the U.S. Justice Department can be difficult, as the Attorney General is appointed by, and answerable to, a partisan president. This gives presidents the power to try to influence the Attorney General to pursue a political agenda. President Richard Nixon did this during the investigation of the Watergate break-in, which threatened to implicate him in criminal acts and end his presidency. On the evening of October 20, 1973, Nixon ordered Attorney General Elliot Richardson to fire Archibald Cox, whom Richardson had appointed to lead the Watergate investigation. Richardson refused and resigned. Nixon then ordered Deputy Attorney General William Ruckelshaus to fire Cox. Ruckelshaus also refused and resigned. Finally, Nixon ordered Solicitor General Robert Bork, the next most senior official at the Justice Department, to fire Cox. Bork complied. This dramatic series of events, often referred to as the Saturday Night Massacre, demonstrated how presidents could exercise political power over federal criminal investigations. After the Watergate scandal, Congress considered legislation to make the Justice Department into an independent agency in order to better insulate it from presidential influence. This would have been in line with what many of the founders originally intended. But Congress decided on more modest reform and passed the Ethics in Government Act of 1978, which was enacted by President Jimmy Carter and created the Office of Independent Counsel. A judge's stunning decision to dismiss the classified documents case against Donald Trump brought an abrupt halt to what experts have considered the strongest and most straightforward of the prosecutions of the former president. But it's hardly the final word. Special Counsel Jack Smith's planned appeal of U.S. District Judge Aileen Cannon's order is expected to tee up a court fight that might reach the U.S. Supreme Court and could result in the reinstatement of the indictment and even conceivably the reassignment of the case to a different judge. There's no scenario in which a revived prosecution could reach trial before the November election, and it presumably won't take place at all in the event Trump is elected president and orders his Justice Department to dismiss it. Still, Cannon's order ensures many more months of legal wrangling in a criminal case that became snarled over the last year by interminable delays. The only good thing about this is that it is finally a decision, said Nancy Gertner, a former federal judge in Massachusetts who was nominated to the bench by President Bill Clinton, a Democrat. The difficulty with Judge Cannon has been that she has made no decisions. She has simply sat on the case. And since she has made no decisions, there was nothing to appeal. The judge's 93-page order held that Smith's selection as special counsel violated the Constitution because he was named to the position directly by Attorney General Merrick Garland instead of being appointed by the President and confirmed by the Senate. Prosecutors vigorously challenged that argument when it was raised by Trump's lawyers. It's impossible to say whether the opinion will stand or be reversed on appeal, though other judges in other districts in recent years have reached opposite conclusions of Cannon, upholding the constitutionality of special counsels who were appointed by Justice Department leadership and funded by a permanent indefinite appropriation. The Supreme Court, in a 50-year-old opinion involving President Richard Nixon, held that the Justice Department had the statutory authority to appoint a special prosecutor. And even though Supreme Court Justice Clarence Thomas raised questions this month about the legality of Smith's appointment, no other justice signed on to his concurring opinion in a case that conferred broad immunity on former presidents. The Smith team is likely to point to all of those court holdings in casting Cannon to the Atlanta-based 11th U.S. Circuit Court of Appeals as an outlier who made not just a bad decision but an irreversibly bad decision, said Michael Gerhardt, a University of North Carolina Law School professor. A spokesman for Smith's office, in announcing Monday that the Justice Department had authorized an appeal, said the opinion deviates from the uniform conclusion of all previous courts to have considered the issue that the Attorney General is statutorily authorized to appoint a special counsel. But Jesse Panuccio, a former Associate Attorney General in the Trump administration Justice Department, said anger over Cannon's opinion, which he called a careful and scholarly analysis, was misplaced. If you took out of the equation the derangement that comes from anyone analyzing anything that has to do with Trump and you just asked legal scholars 10 years ago, hey, are there any issues involving independent counsels, special counsels? said, the answer would be yes. Panuccio added, I think this is a very serious issue, and it's an issue frankly that when I was at the Justice Department, I had reservations about. Trump on Monday said the dismissal should be just the first step, and the 3 other cases against him, which he called witch hunts, should also be thrown out. Cannon, a Trump appointee, has exasperated the Justice Department since even before the indictment was filed, meaning if prosecutors do seek her removal, they could presumably cite a laundry list of grievances with her handling of the case. Weeks after the FBI searched Mar-a-Lago for classified documents in August 2022, Cannon granted a Trump team request to appoint an independent arbiter to review the seized records, a decision later overturned by a unanimous federal appeals panel. It is unclear if Smith's team will seek to have Cannon reassigned in the event that the appeals court reinstates the case. A Smith spokesperson declined to comment Tuesday on that possibility. It's an unusual request and one prosecutors in this case had avoided making. But there is precedent for appeals courts taking that step, including in the same judicial district where the Florida case was charged. I think it would be quite a statement if the circuit court removes her from the case, but I think in this instance it would be warranted, said Cheryl Batter, a Fordham University Law School professor and former federal prosecutor. There does seem to be a pattern of Judge Cannon bending over backwards to create delay and obstacles. In 1989, the 11th Circuit reinstated a criminal case in Florida of a man charged with trafficking counterfeit Rolex watches and reassigned the case to another judge after the trial judge described the case as silly and a waste of taxpayers' money. The court laid out 3 considerations for deciding whether to assign a case to a different judge, including whether such a move is appropriate to preserve the appearance of justice, and whether the original judge would have difficulty putting his previous views and findings aside. Gerhardt, the North Carolina professor, said he did not see a downside to Smith's team making such a request. Judges do make bad decisions sometimes, he said. But not good judges do it more often than they should, and she's done it more often than any judge should. But Panuccio said he didn't think Cannon's order gave Smith's team a sufficient basis to complain, especially given that Cannon's position was backed by a member of the Supreme Court opinion. I think Jack Smith would be flirting with fire if he were to make that request based on this opinion simply because he lost an issue, he said. Judge Aileen Cannon's rulings in the documents case had fueled questions about favoritism and legal acumen even before she threw out the charges that Donald Trump had mishandled classified documents. Judge Aileen M. Cannon had made any number of unorthodox rulings. In fact, since Judge Cannon took control of the case in June 2023, many of her decisions have been so outside the norm that they have fueled intense criticism of her legal acumen, stoked questions about favoritism toward Mr. Trump, and slowed the documents case sufficiently that it would not come to trial before Election Day. Still, almost no one, including some defense lawyers working on the case, expected Judge Cannon to throw out the charges against Mr. Trump by ruling that Jack Smith, the special counsel who filed the indictment, had been unconstitutionally appointed to his job, especially on the first day of the Republican National Convention. The ruling upended 25 years of Justice Department procedure for naming and governing special counsels and called into question decisions by previous courts reaching back to the Watergate era. The very definition of an activist judge, she has single-handedly upended 3 decades of established law historically used fairly and in a bipartisan manner, said Joelle Ann Moreno, a law professor at Florida International University. From the moment that Judge Cannon was assigned to the case, there were questions about her ability to handle it. She took control of one of the most significant prosecutions in American history, rife with legal and political complexities, even though she had been a judge for less than 4 years and had extremely limited experience in overseeing criminal trials. On top of all that, the main defendant was the president who had nominated her to the federal bench. Her colleagues in the Southern District of Florida were concerned enough about her stewardship of the case that not just one, but 2 of them approached her early in her tenure and asked her to consider stepping back and handing off the matter to another federal judge. One of the jurists, the chief judge of the district, suggested it would be inappropriate for Judge Cannon to continue on the case because of a ruling she had made in Mr. Trump's favor in a related civil case after the FBI had searched Mar-a-Lago, the former president's private club and residence in Florida, in August 2022. In a move that drew national scrutiny and criticism, Judge Cannon intervened in the civil case and barred the Justice Department from using any of the documents that agents seized from Mar-a-Lago in their inquiry until an independent arbiter had sorted through them for any that were privileged.
Judge Aileen Cannon's dismissal of the classified documents case against former President Trump is his second major legal victory in weeks. In a 93-page ruling, Cannon said the appointment of special counsel Jack Smith, who's overseeing the case, was unlawful.
A spokesperson for the Department of Justice says it will appeal the ruling, and joining us now is Mary McCord. She was acting head of the Justice Department's National Security Division and a longtime U.S. attorney. Mary, thanks so much for being with us.
And Mary, we should point out here that this was not dismissed on the merits of the case, but rather, as we pointed out, it was about the way in which special counsel Jack Smith was appointed by Attorney General Merrick Garland. Other federal courts have upheld the constitutionality of special counsel. So based on your understanding, how out of step is the judge here with what you know legal precedent to be?
Well, she's quite out of step with the legal precedent. And I would say all of the cases, all of the courts who have upheld the appointment of the special counsel in the past, they've relied on a Supreme Court case called U.S. versus Nixon, which accepted for purposes of that case that the Attorney General had the authority to appoint special prosecutors with special responsibilities, and actually pointed to the same statutes that the Attorney General in this case relied on in appointing Jack Smith. But, you know, who she's not out of step with is Justice Thomas, who in his concurring opinion in the immunity decision spent several pages. In fact, the entire point of his concurring opinion was to call attention to the fact that he thought it needed to be examined whether the appointment of Jack Smith violated the Appointments Clause. And that's not an issue that was before the court in the immunity case. It hadn't been briefed. It hadn't been argued. Nevertheless, he set out a roadmap for determining that the Appointments Clause was invalid. And if you read his short concurrence and her much longer opinion, Judge Cannon's much longer opinion, you'll see that she basically took his roadmap, added some more flesh to it, and that's her decision.
Mary, among the remaining cases facing the former president, this classified documents case was largely seen as the clearest cut. Could the special counsel Jack Smith bring this case in another jurisdiction, in D.C., for instance, where the courts there and the judges have far more experience handling these kinds of cases?
So I think the smartest thing, frankly, for Jack Smith, for the Department of Justice to do right now would be actually to re-indict the case, have a U.S. attorney re-indict the case, because one of the main points here is that Jack Smith is not presidentially appointed and Senate confirmed, and even if he's an inferior officer, one of the main points, I should say, of Judge Cannon's opinion, even as an inferior officer, she argues there was no statutory authority to appoint him. Well, you know who clearly has statutory authority to bring indictments is the U.S. attorney. And so this could be rebrought in the Southern District of Florida. Again, it might then end up back in front of Judge Cannon, but at least this argument that the appointment of the special counsel is unconstitutional would be completely off the table, would avoid that issue going through appeals and up to the Supreme Court. A U.S. attorney could bring it in D.C. as well, and legally I think there's jurisdiction there, but that would, I think, receive a lot of criticism as being, judge shopping, looking for someone other than Judge Cannon. But one thing that the department could do in really relatively short order is re-indict the case.
Mary, we saw the former president welcome this decision. He issued a statement online. He also reiterated without evidence that the case had been brought as a result of what he called the weaponization of the Department of Justice. He also said that this should now lead for the other cases against him to be dismissed. What about that? Could this decision have any impact on the other cases he's facing?
Well, I'd say at the outset, it's interesting that he says this shows the weaponization of the Department of Justice, because Judge Cannon, the basis for her opinion really is that Jack Smith is not tethered tight enough to the Attorney General, and that's why the Attorney General lacked authority to appoint him, because he's got too much independence. So it's actually completely at odds with what Mr. Trump is saying. But with respect to application to other cases, right now this is just a district court opinion that is binding on no other judge outside that district and no other judge in that district. Now, so it does not necessarily mean, for example, that the January 6th case will be dismissed on this grounds or anything that would be the only other one, I guess. But certainly we will see Mr. Trump filing, I expect, any moment now, any day now, filing something before Judge Chutkan in D.C. District Court. He may wait till the judgment actually comes back from the Supreme Court, but I suspect he will file there, asking the judge now to consider dismissing that case, but on the same grounds that Judge Cannon dismissed the Mar-a-Lago case.
And briefly, Mary, is there any universe in which the government's appeal of this case could give Jack Smith an opening to push to have Judge Cannon removed from this case?
So he could appeal this decision to the 11th Circuit and also seek her recusal. In doing so, though, he'd be bringing, a lot more into that than just this decision, I think. I think he'd be having to he would need to set forth a number of her decisions and opinions that and make a case that she is biased and should be taken off this case. I am not going to put money on Jack Smith doing that. Again, it is extraordinary for the Department of Justice to seek to have a judge removed. And it is extraordinary for higher courts to remove a judge. The bar is very, very high when it comes to bias. And I think a lot of people have the opinion that she's biased in favor of Mr. Trump. And certainly she has issued favorable decisions toward Mr. Trump. But she has also issued some favorable decisions, obviously not this one, in favor of the government. And so I think it's a very, very steep hill for the government to climb to seek her recusal. But yes, it is on the table as something they could do when they appeal.
All right, that is Mary McCord. Mary, thanks so much for your insights and for walking us through all of this. We deeply appreciate it.
A pleasure.
What's next for Justice Department after Trump's classified documents case dismissed? Judge Aileen Cannon's dismissal of the classified documents case against former President Trump is his second major legal victory in weeks. In a 93-page ruling, Cannon said the appointment of special counsel Jack Smith, who is overseeing the case, was unlawful. The Justice Department is expected to appeal the ruling.
As you leave the page, don't forget to hit the like bell and subscribe to the channel if you haven't done so as yet. Thank you for watching.